This is Agriculture Today. We are joined now by K-State and Washburn University School of Law professor Roger McEowen for an ag law update. But first and foremost, Roger, Happy New Year and thanks for joining us.
Well, thank you, Samantha.
Absolutely. So today you wanted to discuss a very recent event that has gone on. The Environmental Protection Agency has kind of jumped the gun on a definition that's been debated over for almost 40 years now. So let's talk about what the waters of the United States really is.
Yeah, that's right. It's definitely one way to put it, and that's kind of how I view what has happened, is that the federal agencies have come out here with a final rule as to what the definition of a water of the United States is, and of course put out a joint memorandum with USDA to cover what a wetland is for purposes of swamp buster. But they did all of this, and why I think it's appropriate to say that they jumped the gun. They did all of this and put this redefinition out while there is a pending case before the United States Supreme Court on the very same issue. And that ultimately what the U.S. Supreme Court says the definition should be will rule the day, not what the regulatory agencies say, although it is possible that the U.S. Supreme Court may come out with a position that is either what the rule says or very similar to it. We just don't know that at this point in time.
Sure. So, Roger, for those that are listening and they're maybe not familiar with kind of what WOTUS is kind of what it's being called by some, it really started, like we said, 40 years ago with the Clean Water Act. Is that right?
Yeah, actually a little bit further to the Clean Water Act amendments in 1972, where the Congress tried to define what a water of the United States is. And then for purposes of the Clean Water Act, you can't discharge what's defined to be a pollutant into the navigable waters of the United States without a federal discharge permit. So the term that's at issue right now that's in there is navigable waters of the United States. What is that? Well, that's commonly understood when you bring the Corps of Engineers in here. Of course, their role is to regulate navigation, and the EPA's role is to regulate pollution. And what Congress did was they kind of put the two together, and sometimes they don't fit well together and don't make a whole lot of sense. But this issue of what is a navigable water of the United States that requires a federal permit to have a discharge of a pollutant into has really bothered agriculture for about 4 decades because this got into the hands of activist groups. It got into the hands of the courts. The courts have struggled with trying to figure out what Congress's intent was, what the scope of a navigable water is. And this is an important issue for farmers because if you're deemed to have a wetland on your property that is connected somehow to federally jurisdictional waters, you have to have a federal discharge permit. Very, very costly to have that. There are also draconian penalties and fines that come into place if you don't get that permit and you were supposed to. That's what's at stake.
Absolutely. And, you mentioned producers. Obviously, it's a big deal for them with the way this rules one way or another. We'll see. But, the region that is affected most by this is somewhat the upper Midwest. Is that right?
Yeah, I think simply because what the agencies are doing, what the Corps and the EPA are doing with this rule is they're bringing back the pre-2015 understanding of adjacency, kind of what the Obama administration was doing, and some of the courts had taken the position that you don't have to define adjacency by meaning something that abuts or is next to. So if I have a wetland on my property, I have a ditch on my property that it is next to a navigable water, well, okay, we could think of that as adjacency. But what they're doing with this rule is that they're saying not only is that the case, but we can get you there in terms of connecting the dots to say that you have a federally regulable wetland on your property or you have a water in the United States under a significant nexus test. And that is a very big change, and they say that we can establish a significant nexus by a shallow hydrologic subsurface connection to a water in the United States. Well, what that is farm field drain tile. A shallow hydrologic subsurface connection. So if I have Iowa farm ground that's all pattern tiled, I'm in the prairie pothole region in the Dakotas or in Minnesota, or I've got even ephemeral streams in Kansas, these intermittent streams that sometimes have water in them, sometimes don't, have very shallow water table. That is of concern to farmers that produce in those areas with those type of geological and geophysical characteristics.
You mentioned the jumping of the gun in terms of this definition and that the EPA is trying to kind of beat, I guess, the Supreme Court almost to the punch of getting this defined. But really, one way or another, you mentioned that this doesn't change how the Supreme Court may rule. So how do you see this continuing on, this definition debate?
Well, that's a real good question. The case is pending before the Supreme Court. It comes from upper Idaho, and people that were trying to build a home on a lot that they'd purchased that was about 100 yards away from a lake, which does fit the definition of a navigable water. And they didn't have any water on their property, but by virtue of this adjacency and this nexus test that the courts used, they connected the dots and said that you've got to stop development or it's going to be significant fines amounting to hundreds of thousands of dollars. What's before the U.S. Supreme Court? So squarely before the court is, what is the definition of a water of the United States, which is what the agencies just came out and redefined. This is the third iteration of this in about 8 years. And they just go back and forth and back and forth. But frankly, in my mind, they should have waited until the U.S. Supreme Court said what their view of this is, because that's going to define what the law is, and then you write your rules to fill in the blanks and define the boundaries of the framework that the Supreme Court has given you. But no, they've gotten out in front of this, and I don't think it's going to have any bearing on the Supreme Court's determination. It may cause a delay in the Supreme Court's opinion coming out because they might look at that. They may want to comment on it, but I don't think it'll have any impact on the case that's currently before the Supreme Court. The rule doesn't take effect until 60 days after it's been published in the Federal Register. So basically, we can say if they're going to go ahead and publish it right away, just kind of benchmark March 1 in your mind as to when this would take effect. We may or may not have that U.S. Supreme Court opinion by then. So it's kind of an interesting period of time that we're in right now, but this is really troubling for farmers that have any type of drainage tile, that have prior converted cropland, because the definition of that and the way they look at that is going to be changed under this. And that prior converted cropland issue is also a big issue in Kansas as well as in Nebraska and our listening area here.
Absolutely. And when the Supreme Court took up this case, like you mentioned, it's the building of a house that's kind of in question here in this case specifically. Do you think they realized the unintended consequences that this could have on agriculture when they took up this case and then the EPA got involved immediately?
There's actually a long history of U.S. Supreme Court decisions, several significant decisions involving this particular issue. Back about 15 years ago and 20 years ago, they've been down this road twice. Now, unfortunately, in those opinions, they were not clear in their opinions they issued. And in fact, they were so fractured in one case that they had multiple opinions come out just on that one case. And that's what's created the confusion, because the lower courts didn't know which test to apply. They didn't know whether to apply Justice Kennedy's test or Justice Scalia's test, and the courts have been all over the board on this. And that's what's created the problem, and then the agencies have tried to write different rules, and every time the administration changes, we get a different rule interpretation. So I'm hoping this time that the Supreme Court, and they certainly understand the impact on ag that this has, because they've mentioned that in some of the prior opinions. I'm hoping this time that they're very clear on construing Congress's intent when Congress wrote the statute, and gives us some really good guidelines in terms of what the scope of a navigable water of the United States is and how that can impact private property.
I guess they say third time's the charm for a reason, right, Roger?
I hope so.
Yes, absolutely. Well, I think listeners will echo the same sentiment, hopefully, and understanding kind of where this hopeful final ruling will leave us at in terms of understanding what a navigable water of the United States is. But Roger, in the meantime, if listeners are wanting to stay up to date on this case specifically, where can they do that at?
So I've got a lengthy blog article that I just published on January 2. It's on my website, which is washburnlaw.edu/WALTR. It'll also be posted on the Ag Manager website for the Ag Econ Department at K-State.
Wonderful. Well, I will link to that as well in the show notes of today's show, which can be found on agtoday.net as always. So if listeners are wanting to find that, they can find an easy-to-click link there as well. And Roger, as always, thank you so much for your time.
Thank you, Samantha.
Absolutely. Once again, that was K-State and Washburn University School of Law professor Roger McEowen joining us for an ag law update regarding the EPA trying to jump the gun on a final ruling defining waters of the United States. If you're listening to us on the radio and are afraid you're going to miss out on our next segment because you're reaching your destination or have something else that you're having to switch to quickly here, don't forget the Agriculture Today programming is also available as a podcast. Our podcast is easily accessible on all podcasting platforms, including our website, agtoday.net, as well as Spotify, Apple Podcasts, and more. You can simply search us on any podcasting platform, Agriculture Today, Kansas State, and we are more than likely to pop up, and you can follow us there. That way you can simply have us pop up in your regular feed on whatever platform you're using and listen to us more regularly that way. Once again, you can easily access that on agtoday.net or any podcasting platform by simply searching Agriculture Today, Kansas State.